What if I told you the family immigration system you've been counting on for years is about to be shaken up completely? All over the United States, families are suddenly realizing that bringing loved ones to America just became a lot more difficult. In January 2026, the Trump administration announced sweeping changes to the I-130 family petition rules that could affect your ability to sponsor parents, siblings, spouses, and children. If you already have a petition in process, or you're thinking about filing one, the next few minutes could be the difference between keeping your family together or being separated for years. Hello everyone, you're watching US Immigration Intel, and I'm your host, here to bring you the most important updates on US immigration, visas, and policy changes that directly affect your future in this country. Today, we're unpacking the Trump administration's latest announcement on family-based immigration and the I-130 petition process. These changes are scheduled to take effect in early 2026, and if you don't clearly understand what's happening, you could be facing long delays, denials, or even permanent separation from family members. Watch this video until the end, take notes, and make sure you're subscribed to US Immigration Intel so you don't miss immigration updates that can change your life. Let's start with what the I-130 actually is and why it's so central to family immigration. The I-130, officially called the Petition for Alien Relative, is the basic building block of family-based immigration to the United States. It's the form U.S. citizens and lawful permanent residents submit to USCIS to prove they have a qualifying family relationship with a foreign national. Once an I-130 is approved, the government has recognized that family relationship as valid, and your relative can then move forward to apply for an immigrant visa abroad or adjust status inside the United States to become a permanent resident. The I-130 covers a wide range of relationships: immediate relatives like U.S. citizen spouses, unmarried children under 21, and parents of U.S. citizens, plus the family preference categories such as siblings of U.S. citizens, married sons and daughters, and adult children. For decades, bringing close family together has been one of the pillars of American immigration law. Millions of families have used the I-130 process to reunite legally in the United States. Now, starting in January 2026, the Trump administration's new policies are changing how these petitions are reviewed, processed, and approved. These are not minor technical edits. They are major policy shifts that fit into a broader effort to tighten immigration enforcement and cut overall numbers, especially in family-based categories. The first big change is a dramatic increase in scrutiny and documentation for I-130 petitions. Under the new rules, USCIS is demanding much more detailed evidence to prove that claimed family relationships are genuine. In the past, standard documents like birth certificates, marriage certificates, and proof that the petitioner is a U.S. citizen or green card holder were usually enough in straightforward cases. Now, under what the administration calls enhanced vetting, even simple routine I-130 cases are subject to far more intensive review. USCIS is now expecting extensive proof of the history of the relationship, strong financial evidence for spousal cases to show interdependence, detailed sworn statements from third parties, photos covering the relationship over time, and in many situations, certified translations of foreign records from approved translators. In real life, this means preparing an I-130 has become more complicated and more expensive. Many families will need to pay for immigration lawyers or consultants to help them assemble the right evidence. You'll need to pay for official translations, track down people who can write affidavits about your relationship, and collect much more documentation than before. On top of that, cases are taking longer because officers have more material to review. Petitions that used to be decided within 6 to 12 months are now stretching to 18 months or more, just for the I-130 stage, not counting the rest of the immigration process. The second major shift is in the financial requirements for sponsors. When you file an I-130, you're not only proving that you're related, you're also promising to support your immigrant relative financially so they don't become a public charge. That promise is made through Form I-864, the Affidavit of Support. Under earlier policies, you generally had to show income at or above 125% of the federal poverty guidelines for your household size. If you didn't meet that level, you could often rely on a joint sponsor, usually another relative or close friend, who did meet the income requirement. The Trump administration's new rules raise the bar significantly. First, the income threshold itself is being pushed higher. While final numbers are still being set, proposals indicate an increase to 150% of the poverty guidelines or even higher. Second, the use of joint sponsors is being restricted, making it much more difficult to qualify if your own income falls short. Third, USCIS is examining assets more strictly. Simply listing savings or property may no longer be enough to overcome low income unless you can clearly show those assets are accessible and sufficient. Here's how this plays out in everyday terms. Under the current 125% standard, A U.S. citizen sponsoring only a spouse might need to show an annual income of about $28,000 for a two-person household. That figure is already a challenge for many Americans, especially those in lower wage work or who have recently lost jobs. If the threshold climbs to 150%, that same sponsor may need to prove income closer to $33,000 or more. If you're sponsoring multiple relatives, a spouse plus both parents, for example, the required income for a four-person household could easily reach $50,000 or beyond. Many working-class and lower-middle-class Americans don't earn that much, particularly in lower-cost regions or lower-paying industries. In effect, the new rules are pricing a large portion of ordinary families out of the ability to sponsor their loved ones. The third major change is an expansion of the reasons USCIS can use to delay or deny cases, along with a greater reliance on requests for evidence, or RFEs. An RFE is a notice from USCIS asking for more information or additional proof before they make a final decision. Under the Trump administration, RFE rates across many categories have already risen sharply. Cases that once moved smoothly through the system are now frequently interrupted by RFEs demanding more documents, clarifications of small inconsistencies, or explanations for anything the officer finds unclear. The new 2026 guidance broadens the grounds for issuing RFEs or rejecting I-130s outright. Officers have more leeway to question whether a marriage is truly genuine, whether family ties are strong and real, or whether the petitioner is clearly committed to financially supporting their relative. On top of that, the administration has directed USCIS to take a far tougher stance on any inconsistency, even small ones. A mistaken date, a slightly different spelling of a name on one form compared to another, forgetting to list an old address. Issues that might once have been treated as minor and easily corrected are now being used as reasons for RFEs or denials. The underlying signal is that the government wants to make the family immigration process harder, counting on complexity, cost, and uncertainty to discourage people from filing at all. Another crucial change involves the priority date system and visa bulletin movement for the family preference categories. Because there are annual caps on how many visas can be issued in these categories, backlogs have formed, especially for countries like Mexico, the Philippines, India, and China, where demand is high. Your priority date is the day USCIS receives your I-130, and it determines where you stand in the waiting line. You can only move forward with immigrant visa processing or adjustment of status when your priority date becomes current in the State Department's monthly visa bulletin. Under the Trump administration, the movement of those priority dates is deliberately slowing down. The State Department, which publishes the visa bulletin, is under political pressure to reduce the pace of family immigration. The practical result is that even if your I-130 is approved, you might have to wait many more years before your family member can actually immigrate. For siblings of U.S. citizens from the Philippines, for example, the wait is already over 20 years in many cases. With the new bottlenecks, those waits could extend to 25 or even 30 years. The fifth major change concerns adjustment of status applications for immediate relatives who are already in the United States. Many people file I-130s for spouses or children who entered the U.S. on tourist or student visas, or even for relatives who don't currently have lawful status. Historically, immediate relatives of U.S. citizens, spouses, parents, and unmarried children under 21, could still adjust status to permanent residency even if they had periods of unlawful presence, as long as they had an approved I-130 and met the other criteria. The Trump administration is now tightening the screws on those cases. USCIS is taking a much stricter approach to visa overstays and unlawful presence. Even immediate relatives are seeing more intensive questioning, longer processing times, and more denials. Officers are looking for any pretext to deny an adjustment application, small status violations, gaps or contradictions in paperwork, or any sign that they think points to fraud. If your spouse entered with a visitor visa and you married shortly thereafter, USCIS may claim you had preconceived intent to marry and immigrate and subject your case to invasive scrutiny. Different family categories are being affected in specific ways. If you're a U.S. citizen sponsoring a spouse, you will now be expected to present extensive proof that your marriage is real. Joint finances, shared living arrangements, evidence of your life together, and more. More in-person interviews are being scheduled with detailed questions about your relationship history, daily routines, money, and future plans. Officers are watching for discrepancies that might suggest a marriage entered into just for immigration benefits. If you're sponsoring parents as a U.S. citizen, you'll face the same tougher evidence and financial tests. Any past immigration violations by your parents, unlawful presence, previous overstays, prior removals, will be examined more harshly. For lawful permanent residents who are sponsoring spouses or unmarried children, the obstacles are even steeper. You're subject to the preference system with longer queues, you must meet the higher financial benchmarks, and USCIS may even dig more deeply into your own green card history to ensure you're maintaining your status. For U.S. citizens sponsoring siblings, the situation is particularly grim. The F4 sibling category already has the longest delay times in family immigration. Under the new approach, not only are those waits likely to grow, but officials in the Trump administration have openly discussed trying to eliminate the sibling category altogether. That would require Congress and hasn't happened yet, but the fact that it's on the table shows the intent to dramatically cut back family-based immigration. So what can you do to protect your family's chances under these conditions? First, if you're thinking of filing an I-130, do it as soon as you reasonably can. Your priority date is fixed on the day USCIS receives your petition. Filing earlier locks in your place in line. Every month you wait pushes your case further back. Second, put together the strongest, most complete petition you can. Don't aim for the bare minimum. Include robust evidence of your relationship, detailed affidavits from people who know you, photos over the life of the relationship, communication records, financial documents showing joint responsibility, and anything else that clearly demonstrates a genuine family bond. Third, you should seriously think about hiring a qualified immigration attorney. With these new standards and the increased risk of mistakes being punished, professional guidance is more important than ever. A good lawyer can spot weak points in your case, prepare you and your relative for interviews, and craft effective responses to RFEs. Fourth, make sure you truly meet the financial requirements. Review your income carefully in light of the new thresholds. If you're near the line, line up a joint sponsor early, understanding that joint sponsorship is now more restricted and scrutinized. If you plan to rely on assets, be prepared to show that they are liquid and can be readily used to support your relative. Fifth, be absolutely honest and precise on every form. In this environment, false statements or leaving out important details can trigger denials and even permanent immigration bars. Even innocent mistakes can cause serious delays. Check and recheck all your information before you sign. Sixth, if you receive an RFE, respond quickly and thoroughly. These notices usually give you a fixed timeline, often 30 to 60 days to reply. Use that time to gather everything requested and address each concern clearly. If you're unsure how to respond, get legal advice right away. If your I-130 is denied, remember that you do have options, but time is critical. You may be able to appeal the decision or file a motion to reopen or reconsider. These processes are legally complex and require careful preparation, so professional help is important. In some situations, it might be wiser to correct the issues that led to the denial and file a brand new petition rather than appeal. The best strategy depends entirely on the reasons for the denial and the details of your case. You also need to stay on top of ongoing policy changes. Under the Trump administration, immigration rules are shifting rapidly. What is true today may be different 6 months from now. Follow reliable, specialized sources like U.S. Immigration Intel, where we explain changes in clear language and focus on how they affect real people. Don't gamble your case on rumors, social media posts, or advice from friends who heard something. Immigration law is technical, and bad advice can destroy your chances. If you've already filed an I-130 before these new policies took effect, don't assume you're safe. USCIS can, and often does, apply new standards to pending cases. That means your old petition might suddenly be examined under the new, tougher rules. If you receive an RFE asking for more evidence, that's a sign the new policy framework is being used in your case, and you need to respond at the higher standard. If you're thinking about different immigration paths, keep in mind that family-based immigration isn't the only route. Depending on your skills, background, and circumstances, you might look at employment-based visas, the diversity visa lottery, humanitarian options like asylum or refugee status, or in some situations, returning to your home country and applying from there. Each path has its own rules and obstacles, but it may be worth exploring alternatives with a professional. There are also common mistakes people make with I-130 petitions that become even more dangerous under the new regime. One is rushing the filing and sending in an incomplete or weak case. Excitement about reuniting can lead people to submit whatever they have on hand instead of carefully building a strong package. Another mistake is hiding or minimizing past immigration violations. If your relative overstayed a visa, was stopped at the border, or had any other run-ins with immigration authorities, you must disclose this truthfully. USCIS will almost always discover it, and hiding it looks like fraud. A third mistake is allowing your relative to fall out of legal status while the case is pending, when they're in the U.S. Maintaining status can be critical for adjustment of status, and violations can complicate or sink the case. A fourth is failing to notify USCIS of major life changes, moving to a new address, changing jobs, or other significant events. If you miss an important notice because USCIS doesn't have your current address, your case can be delayed or even denied. The Trump administration's stance on family immigration represents a deep shift in the philosophy behind U.S. immigration law. For many years, under both Republican and Democratic presidents, family reunification was treated as a central value in the immigration system. The current administration sees many forms of family-based immigration as chain migration and is actively trying to cut it down. Understanding this helps explain why these new rules are so harsh. They are not random bureaucratic tweaks, but part of a deliberate push to reduce legal immigration numbers across the board. As long as these policies are in place, you should expect tighter rules, more enforcement, and more difficulty in keeping your family together through immigration. I want to be very direct with you. These changes make family immigration much harder. A process that was already stressful, expensive, and slow has become even more demanding. More families will find themselves separated for longer. Some will be denied entirely, even though they might have been approved under past rules. Higher income thresholds and tougher documentation rules will simply shut some Americans out of the system. But that doesn't mean you should give up hope. Every year, even under strict policies, many families still succeed. With careful planning, strong evidence, accurate information, and patience, it is still possible to bring your loved ones to the United States legally. You just have to be more prepared and more strategic than before. Here at U.S. Immigration Intel, our goal is to help you do exactly that. We're committed to tracking these rapid changes, breaking down new announcements from the Trump administration, and explaining how they affect your specific situation. Immigration law is what we focus on, and we aim to be a trusted, accurate, and up-to-date resource for you and your family. If this video helped you understand what's happening, please click the like button and share it with anyone who's going through or considering the family immigration process. They deserve to know what they're facing. Subscribe to U.S. Immigration Intel and turn on notifications so you don't miss future updates. Policies are changing fast, and staying informed is one of the best protections you have. Leave a comment below if you have questions about your own case or if there are other immigration topics you'd like us to cover. I read every comment, and your questions help shape the content we create so it's as useful and relevant as possible. Remember, information is power in immigration. The families who succeed are the ones who learn the rules, prepare thoroughly, and act early. Don't wait until new policies close doors that are still open today. If you plan to sponsor a relative, start getting ready now. Gather your documents, evaluate your finances, and if necessary, consult with an experienced immigration attorney. Acting sooner gives you a better chance. This is U.S. Immigration Intel. I'll see you in the next video. Stay informed, stay prepared, and don't give up on the goal of keeping your family together.